Why Thailand refuses international court in one sense? When territorial disputes arise between nations, international courts are often presented as the most neutral, transparent, rule-based channel for solution. International tribunals, such as International Court of Justice, exist to scrutinize treaties, historical evidence, official charts, and legal principles to determine exactly where international law stands. Yet, when dealing with its neighbors, most notably Cambodia, Thailand has repeatedly and aggressively resisted international judicial interventions, fiercely promoting closed-door bilateral negotiation instead. Why does Thailand consistently run away from international courtrooms? First, the primary reason for Thailand's reluctance to face an international tribunal lies in its raw legal weaknesses of its territorial claims. According to international legal experts, Thailand faces a structural crisis because its border claims rely heavily on modern, internally produced military maps, such as its preferred 1/50,000 scale tactical charts. These maps were drawn unilaterally by Thai military and explicitly carry disclaimers in their margins, stating they are not authoritative boundaries. If a dispute is submitted to an international court, judges do not look at a single nation's internal military drawings. Instead, the court strictly scrutinizes the jointly accepted legal binding boundary documents. For the Cambodia and Thailand frontier, this means the Franco-Siamese Treaty of 1904 and 1907 and mathematically precise 1/200,000 scale Annex 1 maps. Because an impartial tribunal evaluates evidence according to objective international legal standards rather than domestic political desires, Thailand knows that open legal scrutiny would instantly expose its cartographic claims as hollow illusions. Second, bilateral negotiations offer Thailand structural advantages that a transparent international courtroom completely destroys. Unlike judicial proceedings, which are governed strictly by law and evidence, private bilateral negotiations are heavily shaped by political pressure, economic dependence, and raw military size. Historically, Bangkok has used its larger economy, massive consumer market, and superior military budget as a multi-layered lever to stop negotiations and pressures its neighbors behind closed-door negotiations. An international court acts as a great equalizer. Inside a courtroom, a small nation stands on identical footing with a regional superpower. By forcing disputes into legal arena, like a Cambodia triggering joint compulsory conciliation, the smaller state completely neutralized Thailand's economic and military advantages. Thailand prefers bilateral negotiation because it allows power, money, and influence to dictate the outcome, whereas international court focuses strictly on the text of the treaties. Thailand's deep-seated fear of international courts is also driven by historical trauma. The ICJ's landmark ruling regarding the Previous Temple in 1962 and its subsequent clarification in 2013 remain a bitter pill for the Thai political and military elite. Though historic defeat proved to Thailand that international tribunal issue final binding judgment that completely ignore domestic ultranationalist rhetoric. The international court compelled a Thai military to pull back its markers, dismantle its illegal checkpoint, and physically retreat from sovereign Cambodian territory. Experiencing total legal defeat on the global stage demonstrated to Thai policymakers that international law cannot be managed like a domestic political campaign. As a result, Thailand views international adjudication not as a path to justice, but as a dangerous trap that could force them to surrender occupied frontier lands in front of the international civilized world. Ultimately, the enduring controversy highlight a fundamental truth in grand strategy. If a state is genuinely confident in the absolute strength of its legal case, it has no logical reason to oppose an impartial international review. For the supporter of the rule-based global order, justice is found in the courtroom. For the practitioner of regional coercion, safety is found only in the shadows of bilateral talks.